Hi everyone, welcome to the 𝗙𝗶𝗿 Elder Show. I'm your host, Melissa O'Connor. Today I wanted to talk to you about durable powers of attorney and healthcare surrogates. What's the difference and what they are and why you need one. So in Florida, we have what's called a durable power of attorney that people use to help them have a backup in place should they need assistance with handling of their financial affairs. There's also another designation called a healthcare surrogate, which is also a person that serves as your backup should you not be able to make your own medical decisions and don't want your doctors to be making these decisions for you. Your durable power of attorney could include a healthcare surrogate, but it doesn't have to. So many times people have two separate documents. One document which they have for their medical decisions called a healthcare surrogate that basically designates the person that you trust and know that you want to make medical decisions for you on your behalf should you not be able to make those decisions for yourself. Every single person that's above the age of 18 should have in place a healthcare surrogate. The last thing you want to do is have your family find you in a situation where you can't make medical decisions and they want to make decisions for you only to be advised by the medical facility that they don't have a healthcare surrogate on file and the doctor is going to be the person that makes the medical decisions on your behalf, not your loved one. Nobody wants to have that predicament. We would much rather have in place the person that serves as your backup, that serves as your voice, should you not be able to do that yourself. So that's a healthcare surrogate. It's really critical. I encourage everybody to have one in place. I offer little workshops at my children's high school for young people who are now turning 18 and leaving to go to college or the military or trade school or whatever in their life, that they put this document in place so that way as they enter adulthood, they have a safety net in place. So let's get back to the durable power of attorney. Many people think, because the law changed in Florida, many people think that if you have a durable power of attorney, which is essentially your backup, right, the person who's going to serve as your agent for financial affairs, they can handle all matters, which may include health care decisions if you put that in there, but it may just be all your financial decisions, whether the power to sue people, to represent you should you be sued, move monies through accounts. It could be even handling your digital assets and your family pet. We could, depending on how you draft your durable power of attorney, you can give your backup, your person, that your trusted person, authority to handle all these affairs on your behalf. Previously in the state of Florida, there was such a thing called a springing power of attorney, meaning it only sprang to life should you be incapacitated. Those no longer exist. If you have one from years ago, that's still valid, that didn't become invalid, but you can't draft a power of attorney any longer in the state of Florida that only springs to life if you were to find yourself incapacitated. So these days, if you draft a power of attorney in the state of Florida, the person that you designate as your backup has this authority to act on your behalf immediately. So you don't have to be incapacitated, you could just be busy. You could be overseas, you could be sick but not incapacitated, meaning your brain works, you're fine, you can make decisions, but you know what? You're just in a place right now that you're working on healing and getting better, and the last thing you need to be doing is running around town, going to financial institutions or making decisions or handling stressful events. Your power of attorney can take care of all those events for you while you focus on just taking care of yourself. So there's really some great benefits to having a power of attorney in place, and lots of people, when faced with the decision as to if they want to even put this in place, are scared. They're like, what if I gave this authority to somebody and they use it maliciously? Well, I want you to be clear that the person that you designate as your attorney in fact, or the person that has the authority to act on your behalf, your backup, your power of attorney, they have a fiduciary duty to you, meaning they have to act only in your best interest. They can't be taking actions that are not in your best interest, because if they do, they can be liable to you for those bad acts. So there is the protections in place, and it's always nice to have your backup team known and in place, and somebody you trust. And of course, if that changes, many times people may have their backup as their spouse, and then divorce happens. You just change it. You just change your power of attorney. You just change your healthcare surrogate designation, because you have a change in life circumstances. Things happen, we grow, we change, and these documents are living documents that can change with you. But I do encourage people to have these safety nets in place, so that way, if you find yourself in an unfortunate predicament and you need to rely on your backup team, they are there for you, and they can effectuate business on your behalf and take care of you. I hope that this video has been helpful to you. If it has, if you would please like and share content with those friends or family members that you think would enjoy this, I would greatly appreciate it. And I look forward to talking to you again.